So here is a cashier's check, a notice of right to appeal after trial for the City of Evansville Municipal Court. Here's the motion for a new trial or dismissal for the Circuit Court for Rock County. That's where the municipal courts go to on appeal. And here is the notice of appeal. I gotta admit that the first one I wrote was not correct. I changed the statement of facts to reflect something I learned about an hour and a half ago. That the case and the charge were not properly, was properly charged, but I only entered one plea of not guilty, and I was charged twice. So they didn't tell me that I had a second charge until 2 months after I was charged, in a letter saying that the second charge was going to be dismissed, the one I had no knowledge of. I was sent two cases, two citations. Well, no, I was given one citation, this one, in my hand, and a couple of weeks later, this one showed up in the mail. But as you can see, these two citations look very, very similar. So when I seen this one arrive in the mail, I was like, well, that's the same citation as the one I got in my hand. So they just sent me two copies of the same citation. No, that's what I thought for 2 months. 2 months later, I get a letter from the prosecutor saying that there are two citations. Like I said, this citation is the one I got in the mail. This is the one that I thought they sent a copy of. They sent a copy of this one because they look just alike. So I know that some courts send you a second copy of the same citation in the mail. But if you don't look at the details, you won't know that there's a difference. You see the last two numbers?
Bend over by the door, please.
They are different. So the and also for 2 whole months, I never entered a second plea. So this is a plea I entered, not guilty. This is a second charge I got. I never entered a not guilty plea for this. All right. So technically, you're supposed to have 2 pleas. And I think the prosecution and the judge and the secretary decided to keep me oblivious of 2 charges until the very end, or 5 days before the case, where you would need, at a time, you would be preparing for 1 charge. So when I arrived to court, I started preparing for 2 charges. No, so 5 days before trial, I didn't know which case was which. I didn't know what this one was, because the citations look exactly alike. And I had no idea which case was going to be tried. So I assumed that this case was going to be tried. Or the EMS. I didn't look at the citation numbers anymore. I ignored the citation numbers. I looked at the second charge. The newest charge was the one that was going to be tried, because I just entered a motion to dismiss. So I assumed the motion to dismiss that I entered was granted, and that's what the letter from the prosecutor was about. Your motion to dismiss was granted. So I assumed that when I entered the motion to dismiss for this case, it was dismissed. That was the one that they were talking about. But in reality, they dismissed this case, a case I didn't enter a motion to dismiss for until the day they gave me a letter informing me that they were going to dismiss a case that I believe was this case. But it wasn't. They were just dismissing this case without me ever submitting a motion to have it dismissed. They dismissed it on their own. So when I came to court, I thought this motion I submitted was a motion that they granted for dismissal, the first case. But it wasn't. So when I showed up to trial, I was prepared to fight this citation, but this citation was dismissed. So they were very smart. They were very, very smart. They were They were conniving. They didn't allow me to recognize that there were 2 citations, and they caused me to be unprepared, to assume the motion for dismissal was granted for this case, and the newest charge that I was just made aware of was the one they were going to fight. But that wasn't the case. They dismissed this one all by themselves. They didn't grant this motion to dismiss, and they tried me for it at court, which is the case that I stopped thinking about 5 days before, and I started focusing on this case. You get the confusion? So the prosecutor said there was no confusion, but there's a lot of confusion. If you don't inform somebody right away they have 2 charges, they can't prepare for trial. And 5 days before they go to trial, it's really difficult for people to make a switch from fighting circumstances in this case to fighting circumstances in this case, or preparing to fight circumstances in this case to going back to prepare to fight circumstances in this case. I didn't spend 2 months preparing for this case. I spent a couple of days, and I spent a couple of days preparing for this case because that's the one I thought the trial was about, because this case was dismissed. I filed a motion to dismiss this case, and a case was dismissed by the prosecutors, but that case was this one. I had no knowledge that prosecutors can dismiss cases without you filing a motion to dismiss it. So I assumed, because I filed a motion to dismiss a case and I filed a motion for this case to dismiss it, that's the one the prosecutors dismissed, and I was preparing to go to court to fight this one. But the reality is the prosecutor dismissed this one and didn't even hear my motion to dismiss this one in front of the court. And that's the one the trial was about. So they were really smart, very manipulative people. And they started this manipulation by not informing me that I had 2 charges for 2 months. I never entered 2 not guilty pleas. So that's why you formally charge everybody. That's the first step. And this court failed purposefully so that there was confusion close to the trial that would prevent someone from properly preparing for the trial. But anyways, everything I just said, this last 7 minutes are irrelevant. What is relevant is that go fuck yourself is not illegal. It is a protected freedom of speech at all times unless 3 things happen. There's violence, the potential for violence, or a true threat is heard. The judge told me that there was a potential for violence, potential for a disturbance, and that's why you were cited. But people hearing you say go fuck yourself or noticing that you said go fuck yourself is not a disturbance of significance. So you can speak freely, and anytime you do speak freely, people around you are going to hear you. So whether you're loud or quiet, people are still going to notice you if you swear. And the judge decided to judge my manner of speech, which is illegal. We have the freedom of speech for a reason. So one man's lyrics is another man's something. But anyways, your manner of speech is protected. What's not protected is violence, the potential for violence. So the judge said volume and profanity was a manner of speech that wasn't protected or caused me to be charged for a crime. That's not true. That's a bad precedence. That contradicts First Amendment. You can't charge people for their manner of speech. You charge them for the outcome of their speech. And the judge can't prove beyond patrons noticing or hearing my words that there was going to be any further disruption beyond hearing my words. So you got to prove there's going to be further disruption than just hearing words that are spoken that offend you or grab your attention. All right, so I'm going to submit this, and hopefully the Rock County protects free speech. All right.
Is the expected delivery on the tracking
on there as well? It should be right above that tracking number.
All right.
There's just acceptance date.
Oh, okay. So it doesn't have the. So what did you send it through? Priority? Or
It's just ground advantage. It gave me an estimate when I bought the label of like Tuesday, but
yeah.
that's fine.
So it's usually our ground advantage is like 2 to 5. So my guess is to.
That's what happens in the courtroom.
So like
When people are trying to pull something over you, you're focused on a case that you're not supposed to be focused on. You're prepared for that case.
It's going to be usually.
And suddenly the trial is completely different.
But my guess is that they'll probably be up on Tuesday.
They're smart.
Have a good day.
Yeah, me too.
Hello, sir.
Ready to go?
Yes, I would like a certified mail, and then I would like to record as being certified so I can like post it.
Okay, yeah, no problem.
Thank you.
Okay, so we're putting everything in here though?
Yes.
You mind putting everything in that envelope and getting it ready to go?
Right now?
And
Yep.
then, yeah, and then I'll be able to send that for you.
You got it. All right.
Yeah, they just want you to do that yourself because they don't want me adding anything else to it.
I hear you. I should have should have done it over there.
No, that's fine. No big deal.
All right. So, bingo, and then I'm gonna fold these up in there.
Okay.
Make sure it's nice and obvious, and I've been having some strange experiences, and
Oh no.
yeah, man. So I'm kind of
Is that good to go? Yeah, I can take that for a minute.
become precautious.
Yeah, I don't blame you. Especially in this day and age, it's good to check your T's and dot your I's and stuff like that, so.
Excuse me, is this free?
Yep, those are free.
Thank you.
Come on. Yeah, man.
And if it's not perfectly flat, that's fine, as long as you can just fit it in there.
Got it.
It might bulk it up a little bit. It's no big deal.
Take this out and then put this in. That could probably. Oh crap! I don't think it'll fit. I thought these fit in there.
Let's just try to squeeze it in.
There it is. There it is, man. It was that little fold.
That little tiny flap, yeah.
Yeah. All right. Thank you.
No problem.
All right. Bingo. Okay. And then you lick these. Oh, you had tape.
I
right
could have
there.
gotten it for you.
Yeah, cool.
So you didn't have to lick it.
Thank you. Appreciate it, man.
Problem, sir. There you go. All right, so 59 cents for the envelope.
You got it.
And then we'll be shipping this with a 76-cent stamp.
Got it.
And then we'll get that tracking on there for you.
Thank you.
All right, so the statement, you can just hit continue. And then it's just paperwork, so you can hit no for the... All right, so this will be just a $1.01 stamp because of the weight.
Okay.
And then we'll add that certified. That'll make it $5.86.
You got it. Wow. That's it? $5?
Oh yeah. Post office, we try to be the most affordable for your wallet. But if you need something that's like definitely needs to be over there overnight,
Yeah.
some of our competitors do a little bit better than that. But as far as your bang for your buck, this is going to be the best one for you.
Sweet.
All right, so here's the tracking. And then that green slip right there will have that tracking number associated with it.
You got it.
Alright, and then it should be ready for your card. Total's going to be $6.45. Is there anything else I can get for you?
No, that'll do it. Thank you.
Let me get that receipt for you, because that'll also have the tracking number on there,
You get
just in case you misplaced that little green sheet of paper there.
Got it. Sweet. $5.29. Perfect.
And then right there is that tracking number.
Cool. Thank you.
And then just for future references,
Yeah.
be careful where you're taking pictures.
Yep.
It's a federal building.
Yep.
So technically
You're not allowed to.
do on that.
Thank you. Thank you. I heard that, and I don't. I didn't.
You were doing some business. So,
Yes. Thank you.
Yeah, just for future references, some people can be sticklers. So.
Got you. I appreciate your.
Yeah, you want.
Yes.
You have a good day.
You too. He's right. I'm not a First Amendment auditor. I refuse. I would never audit a post office.
I refuse to do it. I know what he was talking about, but I refuse to do that. I think it's retarded. It is a federal building, and I'm not trying to audit any of them. I only started YouTube to tell on gay community harassment. That's it, and implants. That's all I'm here to do. That's it. That is it. So let's just see what happens. Let's see what happens. I think I get protected. Go fuck yourself is protected. So if I yell it and someone's sitting on that balcony over there, if I'm standing on the sidewalk right there, right here, and someone over there hears me say go fuck yourself, that alone is not enough to cause a disturbance. You have a right to speak. The only time that becomes illegal is if those people are in danger because of the words you spoke. So if people around you are hearing you swear and somebody can notice that the crowd was becoming, or the people around you were becoming like threatening, you can be charged with disorderly conduct because it looks like violence is about to ensue. So a disturbance all by itself is not hearing words you don't like. That's not enough. So that's basically what that guy is up there talking about. He's not mad that he's about to be harmed. He's mad that he heard something he didn't like. So in my case, the people at the restaurant who filed a complaint that got me charged were upset about words they heard, but they weren't in any danger. So I wasn't going to hurt them, and nobody around me was going to go inside the restaurant to hurt those people. So there was no further potential of a disturbance because no one was going to do anything. No one had plans to do something illegal or do something to prevent those people from physically enjoying their meals. Mental enjoyment is not something that the federal government or the state can enforce because we share the space we exist in. So if someone has the freedom to speak or exercise their freedom outside a restaurant, and you are hearing things you don't like or seeing things you don't like, you can't call the police to tell them, hey, someone is outside saying or doing things I don't like. Because then they wouldn't have any freedom. And everybody would be calling the police all the time, telling the police department, hey, there's things that we don't like. I just heard someone swear. And it's ruining. He just used profanity. It was quiet, but he's standing right next to me, and he's swearing. Yeah, he's not yelling, but he's swearing. I don't want to hear any profanity. So the police show up, and they arrest some guy because he was using swear words while he was talking quietly, because someone didn't want to hear swear words while they were eating lunch. Now, does that sound like freedom to you? The freedom of speech? Your freedom is protected. Your freedom to speak is always protected. It doesn't matter if you're yelling or if you're quiet. You can swear freely. You just can't have violence, the potential for violence, or a true threat be heard by the words or caused by the words you spoke. So the judge did something that no judge in America is supposed to do. He found me guilty of disorderly conduct because somebody complained that I yelled, go fuck yourself on a sidewalk at an intersection in Evansville. Those people told the police department that it interrupted or it disturbed their experience. But hearing swear words is always going to gain somebody's attention. That's not enough to claim there is a disturbance. Becoming aware that someone's yelling or is not a disturbance. That person's yelling has to prevent you from, and physically prevent you from enjoying your meal. So you would have to know that something bad is about to happen, or this person's words forces you to leave. if someone's yelling bomb or I got a gun or somebody should be shot, those things scare people. Those things make people afraid and make people want to leave. And that's as good as you pushing someone out. You literally physically push them out. So your words can cause a disturbance if it changes the choices of the people around you in a reasonable way. So it's reasonable to expect that if someone's yelling about a gun or a bomb, that people are going to start moving away or leaving the area. Now that's a disturbance. You are now causing the disturbance, and it's reasonable to expect people to leave the area. But someone swearing isn't a reasonable expectation that something bad's going to happen. Something bad is soon to happen. A disturbance greater than hearing those words, go fuck yourself, is going to occur. So normally, go fuck yourself is it's kind of attention grabbing, but no one is afraid of the person yelling go fuck yourself as much as they would be afraid, or like they would be afraid of someone yelling bomb or there's a gun. He's got a gun. Now that would cause a disturbance because people would start running or start looking everywhere for the person with the gun so they can avoid them. Now you are inciting a riot or a gathering or something bad. But go fuck yourself is not the same as there's a gun. That's causing a disturbance. If people suddenly get up out of the restaurant and leave because they're afraid, and a reasonable person would agree that they were supposed to leave because of what you said, then you just caused a disturbance. So if you were yelling blue, 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 you could do that until you pass out. It's your freedom. And people in the restaurant could be annoyed that you are talking outside about something they don't want to hear and leave, but you can't be charged for causing a disturbance because that word or the statements you were making, although annoying and offensive, does not warrant, no matter how loud you were, does not warrant the potential for violence or potential for a physical endangerment that would motivate people, rational people, to get out of there. So I wasn't supposed to be convicted of saying go fuck yourself in public to a police officer at all. And it is a mystery as to what kind of judge would convict somebody of free speech and a civilization that is protects freedom of speech increasingly so. It protects freedom of speech as much as we do. Or talks about go fuck yourself being a freedom of speech that is constantly protected. Even if you yell it, even if you flip the middle finger off at a police officer and kids nearby see you, that freedom is protected. Even if you're yelling that fuck the police and there are kids nearby or there are people at a restaurant, they hear you say fuck the police, that speech is protected. So the people at the restaurant can't say, hey, I heard him say fuck the police. I heard him say it. That's disorderly conduct. The cops can't walk up to you and arrest you. It was loud. A lot of people heard you and you swore. But it is still protected. And I shouldn't even have had to argue to the municipal court judge that yelling go fuck yourself is protected. It's no different than saying fuck the police in public around a crowd of people. So I don't know how or why I got convicted of saying go fuck yourself on a public corner, a public sidewalk directed at a police officer. I have no idea. It should be impossible. It's 2025. That law was put into effect in 1970 or maybe 1960. So I should not have been found guilty. So no matter what my appeal, they just reminded me with an implant to say that no matter what you're talking about, the irregularities in the court case, you were not supposed to be convicted. So they could flip, they could dip, they could rip, they could lip, they could do anything in the world during that court procedures or leading up to the trial, but you are still not supposed to be convicted no matter what. So the fact that you were convicted shows an incredible sign of disregard for the United States Constitution, disregard for the freedoms that are given to every U.S. citizen. And I guess they're questioning whether anyone's going to do anything about it. I don't know. No one's saying anything. No one's just doing anything. No one's talking about your implant. So will they talk about your freedom of speech rights? Probably not. Who knows? Let's find out. We're going to find out if the Rock County Court judge. Oh, I think someone's trying to figure out where all the bad judges are. So I think that's my personal opinion. Somebody is using me to discover where all the criminals are, where all the people who break the rules, break the laws, tell lies, or hurt people. Where are those people? So Evansville has a judge that doesn't uphold the Constitution. Go fuck yourself is a freedom of speech that's protected at all times. He should know that off top. He should have known that. Fuck the police, go fuck yourself, yelled at the top of your lungs, does not warrant a disturbance. It is a freedom of speech. Your words have to lead to violence or the potential for violence. The potential for a disturbance has to be articulated. What was happening that was going to lead, that from my words, that were going to lead people to reasonable person to vacate the area. So I hear swear words all the time. I'm sure people of Evansville have heard swear words all the time, or they've watched the news, or they've seen the videos, or they know the United States well enough to know that people have a right to swear at police officers. And that right is protected. So when they heard me swearing, and they knew someone mentioned, hey, I think he's yelling at the cop, they were supposed to know that, oh, it's one of those First Amendment people. And that behavior is protected. So there's enough people in that restaurant to have spread the word. If they were gathering or they were gossiping or they were thinking about what was happening outside, enough of those people, some of those people would have realized or spread the word that, hey, that's protected free speech. That, you guys know that. That's like First Amendment rights or some crap where you can swear at police officers in public. As long as you don't cause violence or the potential for violence or a riot, or you hurt somebody, or you cause somebody to be hurt because of your words, you're protected. So I don't believe the people in the restaurant were rational, were reasonable to believe that something bad was going to happen to them because of the words I spoke. That is unreasonable. That is an unreasonable psychology. You are not supposed to think that because someone yelled, go fuck yourself, at a police officer, that you, the people inside the restaurant, were going to be harmed. That is an unreasonable expectation. A person on the sidewalk doesn't even know you're in that restaurant, hasn't even identified you as a potential victim. And unless people inside that restaurant planned on hurting you, I doubt anybody in the area, there was nobody in the area, anybody, random stranger, any weird person in the area was going to attack or harm or cause further physical disruption to the people inside the restaurant, or cause physical disruption that physically interfered with their dinner, or reasonably would mentally stop them from eating for fear of physical harm. So the words can cause a reasonable person to think that they're going to be harmed soon. So you don't actually have to physically touch these people. You can give a reasonable person the expectation they were going to be physically harmed. But I was unarmed. I'm wearing earmuffs and a sweatband, and I'm holding a phone to my face and yelling at a police officer. What are the odds that I was going to end up physically causing a disturbance or physically harming or giving a reasonable person an expectation that there was going to be further disturbance beyond someone yelling, "Go fuck yourself" on the corner? And hearing offensive words is not a disturbance. That would mean no one had the right to ever say, "Go fuck yourself" in public, even if it was quiet or softly, because we would always be offended. So manner of speech is not relevant. What is relevant is the outcome of that speech. And the potential for a disturbance is not equivalent to hearing the words "Go fuck yourself." That's not enough. The threshold for a potential disturbance is higher than that. There has to be people acting like they're going to harm the people who complained about "Go fuck yourself," that can articulate how they believe they were going to be harmed or how they were going to be disturbed in a way that would prevent them from finishing their meal. So mental disturbance is not enough. Audible offensive language is not enough. You have to physically disrupt physically or give a reasonable person a mental motive that's just as good as a physical disturbance. So words don't, like "Go fuck yourself," are protected because they don't give the impression that someone is going to be harmed. They don't lead to violence or the potential for violence. It's an expression. It's an expression. "Go fuck yourself" is an expression, and it's protected. And as long as that expression doesn't lead to an impression in someone's life, like a physical impression or the knowledge that a physical impression was coming soon because of the words he spoke to them, no reasonable person would believe that "Go fuck yourself" is a dangerous and would give them an impression of harm. So that judge was not supposed to convict me, and I think it's right to appeal it. I think he thought I was poor, or I was too stupid to follow through on the procedural process, or I would make a mistake if I was confused about the trial process, which in his opinion is quite simple. But it is quite simple. You're supposed to charge me twice. So he's overlooking his flaws and complaining that I don't understand the trial process. The trial process includes being formally charged for every charge you were cited for. So he overlooked his secretary's flaw, didn't even mention it, didn't even explain that, but he scrutinized my procedural, the process, the path, my intelligence. He scrutinized my trial intelligence, but he didn't scrutinize the formal procedure to get the correct number of pleas to match the number of charges from his own secretary. So I think that's unfair to be that judgmental, to be a judge and very judgmental about a defendant, but when your own people make mistakes, you don't even have the leniency or the decency to admit that, hey, we all don't know everything and we all make mistakes. So we're gonna try this case if you're ready, or we're gonna make exceptions for you because you weren't prepared for this trial because of all the confusion, and you weren't formally charged for properly. You weren't giving 2 months of awareness to prepare for this trial, and this last couple of days have been confusing. So are you ready? I would have told him, no, I don't even know what this trial is about. Which case was I about to be tried for? I really don't know. So I prepared for the EMS case because that's the one I was prepared for. And when I got to court, it was a case about the other case. The case I thought was dismissed by my motion. It wasn't. That case was still on the table, and the other case was dismissed without a motion. But no one said that. No one elaborated the details. So throughout this entire case, this experience in Evansville Municipal Court, no one elaborated the details proceeding up to or apologized for not following through formal procedure. So that's where I'm at. And I got charged for go fuck yourself. Either way, man, go fuck yourself is a freedom of speech. But the cop taught the police of Evansville that if it's too loud, you can charge him. That's a lie. That is a lie. His manner of speech is protected. That's the essence of the First Amendment. You can swear, you can yell, you can talk, you can cuss, you can speak fast, you can speak with aggression, you can speak however you want. You can't cause a reasonable person to expect violence, the potential for violence, or a true threat. And the judge described the potential for disturbance as his justification to say I was guilty. So I don't know, is the potential for violence the same as the potential for a disturbance? Disturbing the peace is, the threshold for that is violence, the potential for violence, or a true threat. So he thought, he said to me that the potential for a disturbance is the justification to find me guilty. So that would mean I was going to cause violence was taking place, or I was uttering a true threat. I don't know how the guy holding the camera was going to cause violence or physically interfere with the patrons of the restaurant, but hearing somebody swear outside the restaurant is not illegal. That's not enough. It has to be worse than that. It has to lead to violence or the potential for violence. Or you have to know violence is about to happen. You have to know a disturbance was about to occur. What was going to happen after he said, go fuck yourself? What was the violence? Can you look around and see any potential violence? But I don't know. That's what I'm questioning. I'm trying to figure out why I got charged by a judge. This dude was like 80 years old. He was old. He had little tiny goofball hair, like a retard. Like this dude wanted people to take him serious, but he has a huge bald spot on the top of his head, and he has like little tiny prickly hairs. Like he goes home and gels his hair before trial, and then he wears these clothes. You should have seen his personal clothes. His personal clothes look like a hippie. And then he comes to work and he puts on this robe like he's all serious and he knows the law. But in his private life, he exercises freedoms, the free man lifestyle. And I think he brought those freedoms with him into the courtroom. So he brought his feelings or his perspective that people have a right to experience their dinners without hearing anybody swearing. And therefore, I'm going to charge you and make up lies. Well, make up rationales that contradict the United States Supreme Court's rationale for disturbing the peace or the potential to disturb the peace in order to tell you I'm finding you guilty. So he used the free man lifestyle he practices outside of the courtroom, inside the courtroom. And he found me guilty when he abused his authority. He literally abused his authority. And he was not supposed to find me guilty. That's the bottom line. So nothing else I've said this entire video makes a difference. Everything at the very end makes a difference. I was never supposed to be cited for disorderly conduct, and I was never supposed to be convicted for disorderly conduct if I used protected free speech in the city of Evansville. Go fuck yourself is protected free speech. And it is it is unheard of. It is unknown. It has never been proven to cause the potential for violence, or a true threat. Never. So it's never been heard of to cause a potential disturbance. Go fuck yourself. Go fuck yourself. You can say that all day. If somebody walked up to me and said, go fuck yourself, I can't call the police and tell them, hey, there was a potential disturbance by his words. Something bad could have happened because of what he said. They're going to tell me you have to articulate what you think was going to happen. That's the only way. That's the only way we're going to charge this person with disorderly conduct. And that's what the cops in Evansville were supposed to say. Hey, what do you think is about to happen to you? What disturbance? The words alone are not enough. You have to think beyond the words. So manner of speech is not enough to charge somebody with disorderly conduct. You have to think beyond the words. Will something happen, physically happen, violently happen to disrupt your freedoms? Your freedom to sit here and eat. Will somebody physically change that? Or would his words make a reasonable person leave? Because they were afraid something like a physical push was going to get them out the door. Like somebody physically pushing them was going to happen. So your words have to lead to violence, the potential for violence, or sound like a true threat in order to justify disturbing the peace or causing a potential to disturb the peace. Go fuck yourself is not enough for a rational person who would regular life experiences to think violence, the potential for violence, or a true threat was going to be heard. Even if you yell it, even if it sounds aggressive, that's not enough. So I wasn't supposed to be charged. Like I just said, I don't have to repeat myself. You have to have the potential for violence, or hear a true threat. That is the only way. They just told me a judge was going to circle back. Dude, you know that circle logic? The judge is using circle logic. I think volume causes a disturbance. But I just told you the manner of speech is protected. And it has to rise. The manner of speech has to have an outcome that rises above offensive language alone. That disrupts the freedoms that people are exercising around you. But the judge will respond, well, I think volume disrupts the freedoms of those around you. And I just told you, offensive language, the manner of speech alone is not enough to disrupt the freedoms around you. You have to cause a reasonable person to think that something bad was about to happen because of what you said. So go fuck yourself does not give a reasonable person an expectation that something bad was going to follow. And the judge was supposed to know that. But the judge at Evansville would use that circle logic. Well, I still say volume causes a disruption or the potential for a disturbance. But I just told you volume is a manner of speech and it is protected. You have to look beyond the manner of speech to the potential for violence, the act of violence or a true threat being heard. And the judge will go back to say volume alone is enough to cause a disturbance. But that's not true. Hearing offensive words as you pass somebody who's yelling and swearing is not enough to charge them with disturbing the peace. It has to go beyond disturbing the peace. I mean, hearing offensive language. Hearing those words has to lead to violence. So because I didn't plan on hurting anybody, or they can't prove I planned on hurting anybody, or they weren't going to be hurt, the people who complained can't prove they were going to be hurt, I was not supposed to be charged. So how did I get charged? And how did the judge uphold the charge? The judge abused his authority. There should be consequences.